subject to the conditions, limitations under 47, as we have already discussed that, or already I have shared with you what that section 47 provisions are. Now, what it says, grant of patents to the subject to certain conditions it is actually. So, what that condition is there, you can just check here. Any machine, apparatus or other article in respect of which the patent is granted, or any article made by using a process in respect of which the patent is granted, may be imported or made by or on behalf of the government for the purpose merely of its own use, right? So, government, who is giving us a monopoly? Government is giving a monopoly. Who is protecting our right? Government, because government has created regulatory authorities, court system, administrative measures. So, government is giving us everything related to that patent. Sovereign of the state giving you right on a complete disclosure as per the definition. So, obviously, when government is giving you this right, when it is necessary, obviously that necessary is a very rare phenomenon or very rare situation. But if in that rare situation, if government want to do that, government can use your patent. Definitely, the government have that right. But obviously it is a non-commercial. You just appreciate that government is not doing it for any commercial purpose. Government is, it's like a non-commercial purpose, or some need is there, and for that government is doing that. So that particular thing we have to appreciate. So this is the first condition. Second, you can just say any process in respect of which the patent is granted may be used by or on behalf of the government for the purpose merely of its own use. So government, again, the if process, we talk about a product, we are talking now about a process. So it may be product, it may be process. If it is required, then obviously what will happen? Government can use it, and government have full right, so to use that particular thing. Now next, what further it says that any machine, apparatus or other article in respect of which the patent is granted, or any article made by the use of the process in respect of which the patent is granted, may be made or used, and any process in respect of which the patent is granted may be used by any person for the purpose of merely of a experiment or a research, including the imparting of instruction to people. So this is the particular, we can say, the provision in the Act which helps us in academic system, and therefore in academic system we freely use our patents, we freely do research. If that restriction would have been there, that if that particular provision would not have been there in the Act, every time we have to take a permission from the patent owner. That will be a very difficult scenario for us also, for development of science and technology, which is the jurisprudential base of the patent system. So therefore this is particular provision in the Act, section 47(3), which has given us a right to use freely patent material, use freely to do research on the patented topics. We can do that thing, provided it is only for academic purpose. Next is like a 47(4). What it says, in case of a patent in respect of any medicine or a drug, the medicine or drug may be imported by the government for the purpose merely of its own use, or for distribution in any dispensary, hospital or other medical institution maintained by or on behalf of the government, or any other dispensary, hospital or other medical institution which the central government may, having regard to the public service that such dispensary, hospital or medical institution renders, specify in this behalf by notification in the official gazette.